flavor, the employer and the employee relationship is governed by statutes or regulations derived from a statute. The apex courts, while expounding the law in the case of Imoluami versus West African Examination Council, citation supplied, stated as follows, as I quote, "There is an employment with statutory flavor when the appointment and termination is governed by statutory provisions. It is accepted that where the contract of service is governed by the provisions of statutes, or where the conditions of service are contained in regulations derived from statutory provisions, they invest the employee with a legal status higher than the ordinary one of master and servants. They accordingly enjoy statutory flavor." Learned counsel for the claimant argued that the claimant's employment is one laced with statutory flavor. I wish to supply the relevant paragraphs of counsel's submissions hereunder. In paragraphs 4.04 and 4.15 of his final submissions and arguments, it is stated thus, 4.04. In the instant case, exhibits C5, C6, and C1 are the documents / statutes governing the contract of employment between the defendants and the claimants. Paragraph 4.15. It is our humble submission that the claimant's employment enjoys statutory flavor by virtue of the provisions of exhibits C5 and C6. The claimant's employment goes beyond master and servant relationship. This was what claimant's counsel said. There is no gainsaying that learned counsel for the claimants palpably misconceived the law and misplaced the nature of the claimant's relationship with the defendants. Needless to state the obvious, which is that the documents, exhibits C5, which is a group staff handbook, and exhibit C6, which is a group HR disciplinary process and sanctions policy, which were exalted by counsel to the status of a statute, are no more than corporate codes of conduct and or disciplinary guidelines. For the avoidance of doubt, therefore, for an employment to be properly regarded as statutory or statutorily protected, the employer must be a body created by statute, and the statute or a regulation derived from the statute must make express provisions regulating the employment of the staff or the category of the employee. You may see OBU versus NNPC citation supplied. These elements are conspicuously absent in this claimant's employment. Although the defendant was created pursuant to extant laws in Nigeria, but this does not make it a creation of statute, stricto sensu, as there is no statute that created a defendant's entity, that is United Bank of Africa. I therefore quickly agree with the learned counsel for the defendant that the claimant's employment relationship with the defendant bank does not enjoy statutory protection. It is rather one within the category of a master and a servant relationship, and I so hold. Hence, issue 1 is resolved against the claimant and in favor of the defendant. On issue 2, this issue, which is issue 2, focuses on whether the termination of the claimant's employment by the defendant was illegal or wrongful in law, thus entitling him to the reliefs sought in this suit. Having appreciated the nature of the employment relationship between the claimant and the defendant bank to be a master and a servant contract of employment, one might, however, wonder what this exactly connotes from the legal standpoint. In UTC Nigerian PLC versus Peters, which is a 2022 case, citation supplied, with the aid of the Black's Law Dictionary, His Lordship, the Honorable Justice Olukayode Ariwola, JSC, now CJN, define the master-servant relationship and an employer-employee relationship in the following words, and I quote, "Generally speaking, master-servant relationship is the association between one in authority and a subordinate, especially between an employer and an employee. And an employer-employee relationship is the association between a person employed to perform services in the affairs of another, who in turn has the right to control the person's physical conduct and the course of that service." You may see the Black's Law Dictionary, 9th edition, on page 1402. The crux of the claimant's case, and perhaps the cause of this action, is discernible from paragraphs 6 and 7 of the claimant's statement of facts. These paragraphs state as follows, and I quote, paragraph 6. "By a letter from the defendant to the plaintiff dated the 30th of December 2016, entitled Letter of Termination, the defendant informed the plaintiff of the purported termination of his employment with the defendant." Paragraph 7. "The plaintiff was never served with prior notice before the service of the said termination letter, nor were the requisite reasons stated." End of quote. It is not in dispute that the claimant served in the defendant bank as an employee from the 2nd of January 2009 through the 30th of December 2016, when his employment was purportedly terminated. What remains controversial are the claims that the claimant was not informed of the reasons, if any, for the termination of his employment by the defendant, that the claimant was not given due notice before the termination of his employment, and that the claimant was not paid his salary in lieu of notice of termination. It is trite that evidence is the medium of proof, and proof is the essence of evidence. You may see Anekwe versus State, citation supplied. Having said that, it is important to appreciate the elementary position of our law that in a civil action, the burden or onus of proving an assertion lies on he who is making that assertion. You may see section 131 of the Evidence Act 2011. The person who bears the onus is also referred to as the one who would fail if no evidence were given at all on either side. You may see section 132 of the Evidence Act 2011. However, the onus of proof shifts to the opposition to rebut once the claimant adduces evidence to establish his claim. You may see section 1332 of the Evidence Act. It merits repeated emphasis to state that in a suit where the question of wrongful termination of employment is an issue, it behooves on the claimant, who is the employee, to prove the terms of the employment by credible evidence, and to also show how the defendant, the employer, breached the terms of the employment, as the court would not consider extraneous matters in determining the rights and obligations of the parties. You may see Western Nigeria Development Corporation by Sabimbola, citation supplied. In the instant suits, the claimant adduced documentary evidence in proof of his reliefs. These are exhibits C1, C2, C3, C4, C5, and C6, which were all tendered by the claimant and admitted in evidence by this court. Exhibit C1 is the claimant's letter of offer of employment, which is dated the 15th of December 2008, in which the claimant's employment as an executive trainee on probation is expressed to take effect from the 2nd of January 2009. A section of Exhibit C1, which I consider relevant to the current discourse, on page 2, with the heading Probation / Termination. This reads thus, and I quote, You will be employed on a probationary basis for an initial 6 months. If at the end of that period, your performance is considered satisfactory, you will receive confirmation of your appointment in writing. During the probation period, you or UBA shall have the right to terminate the employment subject to 1 month's notice in writing, and in case of default, a payment of 1 month's basic salary in lieu of notice is mandatory. Subsequently, 3 months' notice or 3 months' basic salary in lieu shall be required. Meanwhile, Exhibit C2 is the claimant's letter of confirmation of his employment, which is dated the 26th of December 2009. Again, it is necessary to reproduce the first salient paragraph thereof, which reads, and I quote, "Sequel to performance during the probationary period, management is pleased to inform you that your appointment with the bank has been confirmed with effect from October 22nd, 2009, end of quote. It must be reiterated that the claimant averred in his pleadings and evidence in chief that he was not given notice of the purported termination or any salary in lieu of the termination. However, it is the defendant's defense that the claimant was paid 1 month's salary in lieu of notice of termination, which is supposedly meant to be the claimant's due entitlement in line with the terms of the claimant's employment with the. The question to resolve at this juncture is whether the defendant paid the claimant's 1 month's salary in lieu of notice, and if yes, whether this is the claimant's due entitlements as per the terms of his employment. In resolving this question, it is necessary to consider the fact that the defendant tendered exhibits D1, A to C, which are the claimant's bank account statements indicating the transactions from the 1st of December 2016 to the 30th of November 2017. Exhibit D1A reveals inter alia 2 credit transactions on the 9th of December 20 in the sums of 163,423 naira 51 kobo and 71,297 naira 91 kobo. There is another credit on the 13th of January 2017 in the sum of 64,661 naira 96 kobo. Paragraph 9 of DW1's deposition on oaths sheds some light on the said credits as follows, and I quote, "Notably, by the applicable terms of his employment, the claimant was entitled to 1 month's notice for the termination of his employment or salary in lieu of notice. Fundamentally, the defendant, by virtue of its letter of December 30, 2016, with reference letter or the reference number, opted to pay the claimant's 1 month's basic salary in lieu of notice by way of 71,291 kobo, which was paid less the required deductions, being sum of 64,667 naira 76 kobo to his salary, staff salary account number dash 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 on the 13th 2017. Now, under cross-examination of DW1, the following is cited from him. Question: see Exhibit D1A. See the entry for the 9th of December 2016. What does it read? Answer: I have seen, and it reads 163,423 naira 51 kobo. Not his basic salary. That was his total salary for the month. Question: he was also paid 71,297 naira 91 kobo as his 13th month. Answer, yes. Question, these are the total sums of salary he was entitled to. Answer, it is incorrect. It was his entitlement for December 2016. Question, according to paragraph 9 again, 71,297 naira 91 kobo is his basic salary. However, money is less by that is 64,667 naira 74. Answer, it means his salary entitlement prorated at the time he was paid 4,667 naira 76 kobo. Exhibit C3 is the letter of termination of the claimant's employment, which is dated the 30th of December 2016. The third paragraph thereof states as follows: your terminal position, as indicated below, shall be passed into your salary account. There is a column showing the following details, and I quote: 1, payment in lieu of notice equals 71,297 naira 91 kobo. 2, total benefits 71,297 naira 91 kobo. 3, unearned leave allowance equals 233 naira 76 kobo. 4, unearned month equals 194 naira 80 kobo. 5, total indebtedness 6,635 naira 94 kobo. Net balance 64,661 naira 96 kobo. At the earliest opportunity in this judgment, that exhibit C1 states that the probation period, the claimant or UBA shall have the right to terminate the employment subject to 1 month's notice and right. And in case of default, payment of 1 month's basic salary in lieu of notice is mandatory. Subsequently, 3 months notice or 3 months basic salary in lieu shall be required prior to the contract of employment. The claimant's counsel strongly believes that the claimant was entitled to 3 months notice termination or 3 months salary in lieu of such notice. I am mindful of DW1 statement under cross-examination that articles 9.4 and 9.2.2 of the conditions of service of the defendant bank stipulates 1 month's notice or 1 month's salary in lieu. Well, I made considerable examination of Exhibit C5, which is the group staff handbook tendered by the claimant himself and relied upon by both parties in this suit. By Article 9.4 of that handbook, it clearly states that UBA may terminate the employment of an employee when applicable, with terminal notice given as defined under resignation above. Article 9.2.2 stipulates as follows, and I quote: an employee who is resigning his employment shall provide notice or make payment to UBA in lieu of notice as follows: for confirmed manager, I believe, confirmed STMGR, that's what it states. 1 month's duration or payment of 1 month's basic salary in lieu of notice. SM and above, 3 months duration or payment of 3 months in lieu of notice. It must be understood that although the claimant's offer of employment letter, which is Exhibit C1, states that subsequently, which denotes after probation, duration of notice required before termination shall be 3 months. However, Exhibit C5, which is staff handbook or policy document number HRG 001 June 2010, came later in time and supposedly contains the terms and conditions of employment of all the staff of the defendant bank, which includes the claimant. Hence, the claimant's that document in this suit. The abbreviation MGR is expressed in 0.2 of Exhibit C5 to represent middle management. The category stipulated to be entitled to 1 month's notice or 1 month's salary in lieu of notice under Article 9.22. The claimant has not disputed being in that category. I am convinced, based on this, that the claimant is only entitled to a month's notice prior to the termination of his employment or a month's salary in lieu thereof, as per the terms of his contract of employment with the defendant. And I saw, as a matter of fact, this court amply finds from Exhibit C3 and from the evidence of DW1 that the defendant opted to pay a month's salary in lieu of notice of termination to the claimant. Having ascertained what the duration of notice required before the termination of the claimant's contract of employment should be, the defendant claims it duly paid the claimant 1 month's salary in lieu of notice whereas the claimant denies this. I must proceed to determine whether the claimant was lawfully given 1 month's entitlement upon the termination of his employment by the defendant. It has been noted that the defendant credited the claimant's bank account with the sums of 163,423 naira 51 kobo and 71,297 naira 91 kobo on the 9th of December 2016, Exhibit D1A. Apparently, the claimant has some squabbles over these payments, particularly about what they actually represent. In paragraph 4 of the claimant's reply, it is stated that the sums of 163,123 naira 51 kobo and 71,291 kobo paid into the claimant's account by the defendant on the 9th of December 2016, were the claimant's basic salary for December 2016 and the 13th month's salary, respectively. Interestingly, the claimant's counsel submitted on page 5 of his final submission and argument that the sum of 4,661 naira 96 kobo is not the in lieu of notice, but a payment identified as net benefits as readable from the account statement, Exhibit D1 A to C. I hold the firm view that the claimant is merely trying to be clever. He perhaps expects to see the salary in lieu of notice boldly written on the face of Exhibit D1B before he will accept that it was his 1 month's salary in lieu of the notice of termination. I believe that a recourse to the content of Exhibit C3, on which the claimant's terminal benefits are clearly engraved in black and white, leaves no one in doubt as to what the sum of 64,661 naira 96 kobo paid into his account by the defendant on the 13th of January 2017 represents. For the avoidance of doubt, paragraph 3 of Exhibit C3, which is the letter of termination, reads thus, and I quote, "Your terminal position as indicated passed into your salary account. It is also clear from Exhibit C3 that the expression payment in lieu of notice, that is 71,297 naira 97 kobo, is vocally manifest and forms the computation that resulted in the sum of 64,661 naira 96 kobo. The said sum of 64,661 naira 96 kobo was realized after the sum of 6,634 kobo, termed total indebtedness, was deducted from the sum of 7,297 naira 97 kobo, already quoted to be the salary in lieu of notice. I find, and as stated earlier, that in Exhibit C5, the claimant was entitled to only 1 month's notice termination or 1 month's basic salary in lieu of such notice. The term salary has been defined as the amount of money that someone earns every year in their job, including any extra payments they may receive. You may see the Cambridge Dictionary. In other words, the amount the claimant earns every month from his job in the defendant's bank, not including any additions or subtractions, will be his basic salary per month. The claimant's basic salary per month, as placed by the defendant, is the sum of 71,297 naira 97 kobo. This, in any case, was also the same amount the defendant paid into the claimant's personal account on the 9th of December 2016 and referred to as his 13th month's salary. The DW1 stated on the cross-examination that the said 13-month salary is usually the basic salary of every employee in the defendant bank, paid with his salary at the end of the year, gratis, and for the staff services all year long. It is settled that in the case of wrongful termination of employment, an employee is not only entitled to a lieu of notice, but to all other entitlements agreeable and due to him at the time of the wrongful termination of employment. You may see Nigerian Product Marketing Board versus Adewumi, citation supply. This quite explains the claimant's entitlement of 64,661 naira 96 kobo deductions. For the purpose of emphasis, it must be stated that although the defendant claimed that the victims were served on the claimant before his eventual disengagement from the bank, for operations of the automated teller machine, that is ATM, and for lateness to work, stroke insubordination in the course of his employment, there is nothing placed before this court to substantiate these allegations by the defendant. And so it is unsafe for this court to act upon those allegations to have been the supposed justification by the defendant for the termination of the claimant's employment. An employer still reserves the right to terminate an employee for a reason and for no reasons whatsoever, although the courts have come to agree that where the employer states any reason for dismissing an employee, necessary for such employer to justify such dismissal, otherwise the court shall deem same as wrongful or depending on the circumstances of the case. It is pertinent for the parties to note the salient distinctions between a termination and a dismissal under the employment law, as both have legal connotations. In any event, whereas the claimant claims that no reason was defendant for the termination of his employment whatsoever, I found on the contrary that the defendant stated in Exhibit C3 that the claimant was relieved of his employment because his services were no longer needed, required by the bank. Whether this reason is reasonable or not is a different kettle of fish. However, one thing is sacrosanct, which is that this court cannot foist on an unwilling employer. There are a plethora of cases. I observed also that the claimant never challenged the deductibles in Exhibit C3. Hence, it can be safely presumed that same has been admitted by him. Although the counsel for the claimant submitted that the sum of 163,421 kobo was the claimant's actual basic salary, there is no evidence to support this. It would have been curious to ask if the sum of 163,423 naira was the claimant's basic salary in the defendant bank, what then was his gross salary? For the claimant, he apparently provided no answer to this question. Ultimately, therefore, issue number 2 for determination is again resolved against the claimant and in favor of the defendants. For the above reasons given, and for the purpose of clarity in this judgment, the claimant's case fails entirely, and same is accordingly dismissed without costs. Judgment is hereby entered accordingly. That is all.
Ascot, please.
Is the defendant counsel here now?
With profound humility,
Yes, please.
D.C. Ibeziako
Yes.
humbly enters appearance for the defendant. I'm awfully sorry, sir, that the network and connection disruptions prevented me from. D.C. Ibeziako.
Are you an SAN now?
Not as yet, my Lord. Hopefully,
Oh, okay,
God will remember me.
I thought you were wearing a seal.
I received the judicial anointing.
Amen.
With profound gratitude. Amen. My Lord, it's so exciting to participate in these proceedings once more. We miss you very greatly. Thank you so much for the enriching judgment. Very incisive, very, very incisive from the beginning to the end. Thank you so much, sir. Most obliged, sir.
Thank you both. Ms. Ihesi, you will get a copy each immediately after proceedings today. Please talk to the registrar to get a copy.
Thank you, my Lord. We appreciate.
I appreciate you as well. All right, you may call the next case. You may mute your microphone. You see us here. Yes. You may mute your microphone. Call the next case. All right. See here, you may mute your microphone. All right, call the case. Yes.
Yes, my lord. Suit number NICN/OW/13/2019 between His Royal Majesty E.C. Okeke and one Imo State government and the 5 others. That is it, my lord, for adoption of terms of settlements.
What's the suit number again?
The suit number is Owerri 13 W/13/2019.
Owerri 14.
And the parties are.
Sorry, you're breaking.
Owerri 13, my lord.
13.
Yes, my lord. 2019.
2019.
Between His Royal Majesty.
Yes.
Is a Dr. E.C. Okeke.
C. Okeke.
Yes, my lord. Against Imo State government.
Imo State government.
And the 5 others.
All right. Are the council here?
Yes. Yes, my lord.
Yes, appearance.
Profound respect.
Yes, please.
Mike and Okafor.
I can't see you. Mike
and okay.
Yes.
Mike and
Okafor.
And for Nigeria, Okafor, yes, sir.
Yes.
The Lord, my humble appearance is for the claimant. Yes, I'm appearing alone, sir.
For the claimant.
For the claimant, sir.
Yes. Defendants. Yes.
I am O.M. Agu, my lord.
O.M. Agu.
Yes, my lord.
Yes.
My humble appearance is for all the
Yes, I understand you reached some terms of settlement.
Mrs. State Council, my lord, Mrs.
Mrs. O.M. Agu.
Yes, O.M. State Council.
Yes, please.
My humble appearance, my lord.
Yes, please.
Yes, my lord. My lord, adopted our terms of settlement.
Yes.
The matter before my lord Adima, and he gave us a tip to go out of settlement, having seen the way the matter is going.
Yes. Have the parties now settled?
Yes, we have reached the settlement, sir, and have come up with the terms of settlement.
The terms are documented?
Yes, sir. Yes, sir. It's documented, and we are here to adopt same and honorable to use our judgment, sir.
I think recently I was sent the terms of settlement on WhatsApp. Let me read through. Okay. Now, is it the one that was filed on the 25th of May, 2020?
Yes, my lord.
All right.
2023, my lord.
2023, 25th of May, 2020.
2023, 2022, my
2022?
Yes, my lord.
But here it says 2023, the stamp. Let's check the stamp on the front page.
2023.
It says 2023.
Died on 25th May 2023, sir. But dated 25th May 2022 and filed 25th.
But it is 25th May 2022.
That's what dated, sir.
Yes, please.
Dated 25th May 2022 and filed 25th May 2023.
That's 1 year after. 1 year after. Now, there are 3 points of agreement. 3 points of agreement.
Sir?
Am I correct?
Yes.
Yes, yes.
Yes, my.
All right. So, in essence,
Yes.
The third point, the parties have agreed that since the claimant is ready to make more sacrifices, Excellency is free to use his discretionary power to approve for him any amount he wishes out of the total in his amended statement of claims. Is that what you have?
Yes, sir. Yes, sir.
Both parties agreed on that term.
Yes, my lord.
All right. Yes, make your application.
Lord, we humbly terms of agreement and urge the honorable court to use it in judgment. May you please, my lord.
Yes, Ms. Agu.
My lord, we also accepted agreement, set terms of agreement between the parties, and urge my lord kindly settlement of agreement as judgment of the court.
All right. Based on the application made before this court today, consent judgment is hereby entered based on the terms dated the 25th of May 2022, but filed on the 25th of May 2023. Judgment is hereby entered accordingly.
As the court pleases.
You'll get an enrolled order after the court proceedings today. You'll get an enrolled order.
As the court pleases.
As court, please.
Is that all?
Yes, my lord.
Yes, my lord.
Thank you. I wish you all the best.
Thank you, my lord.
For the next case,
My lord.
all the best. Thank you too. Next case.
Yes. Number NICN/OW/36/2020 of the Ogu and the 8 others and 1 government of Abia State and 3
Parties are absent.
but the councils are present.
All right. Appearance.
May I please, Honorable Court?
Yes.
C.O. Ogbo. I'm a Deputy Director with the Ministry of Justice, Abia State. I appear for the defendants.
All right. Ogwe.
Ogbo. Sir? Yes, OGW, sir. Ogbo. COOGW. Mr. Amuze, Mr. Oliver Amuze, the counsel for the claimants, did inform me. We received the notification for this proceeding early this morning. He was already scheduled to be at the Federal High Court, Owerri. So he is aware of the proceeding, but did ask for me to beg or to apologize for his absence and inform you where he is. He's at the Federal High Court, Owerri, as we speak, sir.
That's fine. All right. So what's the case for today?
My lord is scheduled for adoption, sir. And possible, and whatever my lord so deemed here. Yes, my lord.
Okay, please proceed.
My lord, with your leave, and may I? Okay, the defendants will start. The defendants filed a four-page written address dated the 6th day of October 2022. It is dated the 6th day of October 2022, but it's filed on the 31st 3/2023. 3/1/3. Yes. Consequently, the claimants, that's in response, the claimants filed their own written address, which is dated the 30th day of March 2023.
Yes.
30th day of March 2023, but filed on the 31st day of 2023, the next day. We wish to adopt the said addresses, also on behalf of our counsel for the claimant. May I please, Honorable Court, sir?
Okay. Any reply?
No, sir.
Okay. All right. I've already prepared a judgment.
Yes, sir.
In anticipation of. So I'll just read the summary and then. All right, judgment. These claimants were elected as councillors of the various communities under Umuahia North Local Government Council. That is the fourth defendant. Their tenure ran from May 1999 and expired in May 2002. They that long after their service as councillors ended since 2002 to be paid in full their outstanding salaries and statutory allowances owed them, which stands at 43,800,463 naira 10 kobo. They are aggrieved that after years of frantic demands for their entitlements, they were only paid the total sum of 1,861,000 naira and 11 kobo in 2018, which merely reduced the entire debt owed them from 45 million to the current balance of 43,800,463 naira 10 kobo, the amount now sought in this suit. The claimants maintain that despite engaging their solicitors to make a final demand from these defendants, the defendants still remain adamant and unmoved by their pleas. They consequently filed this action here for redress. Now, the claimants' reliefs against the defendants. The claimants' joint writ of complaint was filed along with other accompanying processes on the 22nd of July, 2021. Within they seek the following reliefs. 1, the sum of 43,800,463 naira 10 kobo, being the debt owed the claimants by the defendants, arising from the statutory allowances and salary arrears as approved, computed, and or acknowledged by the defendants. 2, post-judgment monthly interest at the prevailing bank rates on the judgment debt sum from the date of judgment till same is finally and fully liquidated. The claimants opened their case on the 11th of February 2022, relying on the testimony of a sole witness, that is CW1, who is also the first claimant in this suit. A total of 5 documents were tendered through him, exhibits C1 to C5. CW1 was cross-examined by the defendant's counsel, whereupon the claimants eventually closed their case on the same day, that is the 11th of February 2022, without the necessity of a re-examination. Meanwhile, the defendants filed a joint memorandum of appearance, statement of defense, and other accompanying processes on the 4th of October 2021. These processes were filed out of time, I beg your pardon, were filed out of time, but as allowed by the rules of this court, duly regularized via their counsel's application for enlargement of time, which was adopted on the 6th of October 2021. They successfully opened their defense on the 3rd of June 2022, when they called DW1, one elder Eziaha Emelogu, to testify on their behalf. He adopted his sworn deposition of the 30th of March 2022 and tendered no documents. He was duly cross-examined after his evidence in chief, whereupon the defendants closed their case on the same day without the need for re-examination of the DW1. At the conclusion of trial, the defendants' counsel filed his final written submissions and arguments on the 31st of March 2023. The claimant's counsel also filed his on the same 31st of March 2023. That's on the 18th of July 2023. Let me quickly slot it in. On 18th July 2023, that is today, the parties' counsel adopted their respective arguments and submissions virtually, whereupon this court immediately delivered this judgment. Please, I'll go straight to the decision part. Court's decision. I carefully considered the entire processes filed in this suit, to wit, the parties' pleadings, written testimonies in chief, oral testimonies of the witnesses under cross-examination, documentary evidence produced before the court, and the learned counsel's submissions and arguments. This court is convinced that all the issues raised by the counsel for the parties in their respective written submissions are similar in substance and may be safely compressed into a sole issue for determination by this court. Consequently, the sole issue raised by the claimant's counsel is apt and shall be adopted as the sole issue for determination by this court. This sole issue is whether the claimants are entitled to judgment in their favor in this suit. My facts finding reveal that the parties mutually agree on certain facts. The claimants, with the exclusion of the representatives of the 4th and 9th claimants, served as elected councillors in Umuahia, North Local Government Council of Abia State, from May 1999 to May 2002. Also, the fact that the claimants have some outstanding and unpaid salaries and allowances is not disputed. Only the amounts, the extent of the indebtedness on whom the responsibility lies to pay the debts are the centric issues in this suit. This court acknowledges that in civil proceedings, the burden of proof, though not static, is always on the vulnerable party who is likely to lose to establish creditably. You may see Ono Brochere versus Esegene, citation supplied. Section 132 of the Evidence Act states that the burden of proof in a suit or proceeding lies on that person who would fail if no evidence at all were given on either side. Elucidating on the nature of the duty on the litigant to establish his claims, the appellate court in Aliu and others versus Yola and others, 2022 citation supplied, held that, and I quote, the burden is on the plaintiff to establish his claim. This is the evidential burden of proof. It is only after the plaintiff has adduced sufficient credible evidence that the burden of proof will shift to the defendants, and so on and so forth. In proof of their claims, therefore, the claimants call the sole witness, that is the first claimant, to tender 5 documents in evidence. The documents tendered are as follows. 1, Abia State House of Assembly letter dated the 27th of February 2001, Exhibit C1. 2, letter of the Auditor General dated the 26th of September 2005, Exhibit C2. 3, 9 payment vouchers dated from the 22nd of May 2018 to the 28th of August 2018, Exhibit C3. 4, 4th defendant's letter to the 3rd defendant's, 4th defendant's letter to the 3rd defendant, dated the 3rd of May 2017, Exhibit C4, and finally 5, solicitor's letter of the 8th of June 2021, Exhibit C5. The defendant's counsel had stressed, as is issue 2 in his final written submissions, that all the documents tendered by the claimants in this suit are mere photocopies, which do not satisfy the requirements of the extant evidential law, that is sections 89E and 91C of the Evidence Act 2011 for admissibility as public documents. Mere looking at the documents tendered by these claimants, one is not in any doubt that they are photocopies of certified documents. However, it is worthy of mention that on the 11th of February 2022, when these documents were sought to be tendered through the CW1, learned counsel for the defendants had objected to the admissibility on the same grounds now still canvassed. This court nonetheless admitted the documents as exhibits C1 to C5 in the interest of justice and noted that the court shall decide their various probative values at the judgment stage. It is tried by virtue of the provisions of Section 91 of the Evidence Act 2011, titled Rules as to Notice to Produce, that secondary evidence of the contents of the document that is shown or appears to be in the possession or control of the opponent is admissible where the party proposing to give such secondary evidence had previously given a notice to produce its original to the party or opponent who is in possession or control of that document. It is equally crystal clear from the provisions of Section 90 of the same Act that only certified copies of a public document are admissible as evidence and no other. However, the claimants stated in paragraph 5 of their statement of facts that the defendants refused to oblige some of the claimants with the certified copies of some letters which are in their custody. Although there is nothing before this court to prove this assertion, it is notable that the said averment was never specifically traversed or denied by the defendants in their pleadings. I wish to reiterate, albeit at the risk of superfluity, that this court admitted the claimant's documents and marked them as exhibits C1 to C5 in the interest of justice and on the strength of Section 12, sub 2B of the National Industrial Court Act 2006 for the just and judicious determination of this suit. Besides, this court is satisfied that the claimants gave the defendants sufficient notice of the fact that the documents shall be necessary for adjudication before this court. And it was certainly not a stunt pulled over the defendants, since the claimants front-loaded those documents and served same before they were eventually tendered formally and admitted as exhibits. I therefore see no reason to depart from my earlier decision to admit those documents in evidence. The defendant's counsel's objection is once more refused and overruled. The defendant's counsel's objection is hereby refused and overruled. Just a minute. Now, although the claimant's claims were produced in detail at the early stage of this judgment, but for the purpose of specific emphasis, it merits reproduction hereunder. 1. Furniture allowance, claim of 10,261,026 naira. 2. Severance gratuity, claim of 10,261 naira and 26 naira to 10,261,026 naira. 3. Constituency allowance, claim of 513,051 naira, 30 kobo. 4. Leave and recess allowances, claim of 1,026,104 naira and 33 kobo. 5. Transport allowance, claim of 11,971 naira, 971,195 naira, 74 kobo. And finally, 6. Salary in arrears, 11,629,059 naira, 84 kobo. All these claims were made jointly. Now, the sum total of these figures is what they wrote as 45,661,463 naira, 21 kobo. But according to these claimants, each of them received the sums of 94,444 naira, 44 kobo, and 112,333 naira and 35 kobo on the 22nd of May 2018 and the 28th of August 2018, respectively, as part payments of their entire entitlements. Accordingly, when these payments are subtracted from the total sum of 45 billion naira The balance is 43,800,463 naira 10 kobo, which is the amount now sought by these claimants from the defendants jointly. These courts carefully examined the exhibits produced and relied upon by these claimants as a basis for their computations as proofs of their claims to the sum of 43 million naira, particularly Exhibit C1, which is a letter dated the 27th of February 2001. Paragraph 4 of the claimant's statement of facts reads as follows, and I quote, "The Abia State House of Assembly, in its constitutional duties, bid its letter dated the 27th of February 2001, with reference number -- which was sent to all local government councils in Abia State, among others, approved and fixed the statutory entitlements / allowances of elected councils in Abia State," end of quote. A very careful perusal of Exhibit C1 reveals that the said document is headed Abia State House of Assembly, and on the addressees, I beg your pardon, the addressees portion of the letter, the reference number -- can be clearly seen. The letter is titled Remuneration for State and Local Government Office Holders, and the body of the letter reads thus, and I quote, "I am directed to forward herewith attached copies of the remuneration for states and local government office holders for your guidance. Appendix 1 is for state office holders, while Appendix 2 is for local government office holders. The footnotes should be read along with the table for details," end of quote. The letter is signed by one F.K. Okoro for the Honorable Speaker, and attached with the letter is Appendix 2, titled Remuneration for Local Government Office Holders in Abia State. I also observe that the said Exhibit C1 does not reveal any known addressee or receiver and bears no official seal or stamp of authority to suggest that it truly emanated from the Imo State House of Assembly. It is self-evident from Exhibit C1 that some claims by the claimants are unsupported and unfounded if they are based on the said exhibit alone. It is on record that after all, under cross-examination of the CW1, that he was asked about the constituency allowances claimed, which was not found in Exhibit C1, but the CW1 could only answer that the document speaks for itself. I can see at the top of Exhibit C1 a column written "Consts Allowance" and quoted 1,583 naira 49 kobo. It is evident that the said sum of 1,583 naira 49 kobo constitutes part of the total monthly salaries of councillors back then. Surreptitiously, however, in paragraph 11 of their statement of facts, these claimants made a claim for a total sum of 513,051 kobo, 51 naira, 3 kobo as constituency allowances jointly claimed. I earlier noted that this letter is not certified by the House of Assembly of Abia State, as such this court must be circumspect and hesitant to attribute full evidential value to these documents, especially in the face of the irreconcilable facts and the lack of authenticity as required by the Evidence Act. Meanwhile, Exhibit C4 is a letter from the Umuahia North Local Government Council, reference -- which is dated the 3rd of May 2017, and addressed to the Permanent Secretary, Ministry of Local Government and Chieftaincy Affairs, Umuahia. The letter is titled Supplementary List of Unpaid Salaries / Allowances of Political Office Holders in Umuahia North Local Government from 1999 to 2002. The letter is signed by one G.O. Okezie, Treasurer, Umuahia North Local Government, and attached to the letter is a list titled Names and Nature of Claims. This contains the names of these claimants and details of their claims, categorized as severance, furniture allowance, and unpaid salaries. Now, the sum of 2,337,233 naira 70 kobo is stated as the total sum for each of the councillor's severance and the furniture allowances, while the sum of 1,174,153 naira 70 kobo is placed as each of their respective unpaid salaries. From the said figures, it is manifest that each of these claimants, that is as councillors, is entitled to the sum of 3,511,389 naira 3,511,389 naira 49 kobo, which by simple arithmetical computation for all these claimants totals 31,602,505 naira 31,602,505 naira as per the annexure of Exhibit C4. Now it is undisputed that the claimants were paid a total sum of 1,861 naira 11 kobo by the defendants as part of the debt owed to them. You may see paragraph 21 of their statement of facts. As such, when 1,861,000 naira 11 kobo is deducted from 31,602,505 naira, the balance is 29,741,505 naira only. It must be noted that the contents of Exhibit C4 or the list attached thereto was not engaged by these defendants, whether in their pleadings or under cross-examination. The deducible inference, therefore, is that Exhibit C4 is admitted and can be safely reckoned with by this court. Meanwhile, Exhibit C3 is a set of 9 payment vouchers supposedly meant for each of the claimants. In this document, the sum stated is 2,337,233 naira 70 kobo, except for the fourth defendant, which reflects 2,490,750 naira only. The purpose of payments are stated as furniture allowance, gratuity stroke severance, and constituency allowances for 3 years. I observe that the sum stated in Exhibit C3 for the listed allowances are similar to what is contained in Exhibit C4 as their entitlements. The claimants also tendered Exhibit C5, which is their solicitors, O.O. Amuzi and Associates letter of final demand for payment. This letter was written and addressed to the Attorney General of Abia State, the permanent secretary of the third defendant, and the secretary to the fourth defendant. Again, the letter demands for 29,741,505 naira only as being the balance of statutory allowances and arrears of salaries owed these claimants. It is necessary to emphasize that Exhibit C5 was written on the 8th of June 2021, whereas this suit was instituted on the 22nd of July 2021, an interval of about 43 days. It is, however, completely inexplicable from the pleadings and evidence before this court what the reasons are for the differences in the sums demanded by the solicitors to the claimants in Exhibit C5 as their total entitlements, stroke allowances, and unpaid salaries, and the sums now sought by the claimants as per their writ of complaint filed in this suit. Given this lacuna, this court shall not become an independent investigator or speculator for the purpose of unraveling the mystery for the differentials. It is more so settled law that speculation is not the business of the courts. So, have these claimants proven that they are owed a total sum of 43,800,000 naira, being the balance of their unpaid entitlements, allowances, and salaries? Again, Section 121 is a guide, and it states as follows. A fact is said to be proven when, after considering the matters before it, the court either believes it to exist or considers its existence so probable that a prudent man ought, in the circumstances of the particular case, to act upon the supposition that it does exist. Considering the entire evidence placed before me, this court is not satisfied that the claimants have proven the defendant's indebtedness to them in the sum of 43,800,000 naira. I have only so far been convinced that the figures in Exhibit C5, which is the letter of demand by the claimant solicitors, which are supported by the contents of Exhibit C4, letter by the fourth defendant to the third defendant, and Exhibit C3, the claimant's payment vouchers, capture the true indebtedness of the total sum of 29,741,503.03 kobo, or 30 kobo, as the unpaid salaries and allowances owed the claimants, and I so hold. On who bears the responsibility to pay the said debts to these claimants? These defendants averred in paragraphs 1 and 2 of their statement of defense as follows, and I quote: 1, that the defendants deny paragraphs 2 and 3 of the statement of facts, and state further that the first, second, and third defendants are not charged with the responsibility, obligation, or statutory duties of payment of salaries and allowances of the office of elected councillors of all government councils in Abia State, including the claimants in this suit. 2, that further to the above paragraph, the defendants state that the fourth defendant has the sole responsibility of the payment of salaries and allowances of claimants. End of quote. These averments were proffered by the defendants in response to the claimants' averments in paragraph 2 of the statement of facts, wherein the claimants assert inter alia as follows, and I quote: the first defendant is the government of Abia State. The second defendant is the chief law officer of Abia State government. The third defendant is the Ministry of Abia State government that is in charge, manages, and superintends local government councils in Abia State, including their finances, disbursements of funds of local government councils, among others. In Abia State, local government councils, including the fourth defendant, can only spend money as approved and released to them by the first to the third defendants from time to time. And in most cases, the third defendant takes direct responsibility of direct payments to third parties or creditors of local government councils, including the fourth defendants. There is no doubt that these claimants' claims against the first to the fourth defendants are jointly and or severally. As such, I do not hesitate to agree with the submissions of the Learned Claimants Council that Section 7 of the Constitution of 1999 establishes and guarantees systems of local government administrations by democratically elected local government council officials, and further provides that the governments of every state shall ensure the continued existence of local government council structures under laws that shall provide for the establishment, structure, composition, finance, and functions of such councils. It is therefore evident before this court from the provisions of Section 7 of the Constitution that the Abia State government has the responsibility to ensure adequate funding of local government councils in the state, including the fourth defendant local government domain. To establish that the defendants understand the significance of this, their witness, DW1, an inspector in the third defendant ministry, had answered under cross-examination as follows. Question: in your ministry, it is the Abia State government that is in charge of all the affairs. Answer: not at all. Question: what are your functions? Answer: we disburse funds to local governments, among others. Question: you also receive payment vouchers or applications from local governments for payment of certain debts. Answer: unless there's an issue, but the local governments have the responsibilities to pay its liabilities. Question: your ministry operates joint accounts with all the local governments. Answer: yes. So respecting the issue of responsibility to pay the claimants their arrears of salaries and allowances, what is deducible from the totality of evidence before this court is that local government councils in Abia State, including the fourth defendant, Umuahia North local government, owe the primary responsibility of paying the salaries and allowances of all elected councillors, including these claimants. This opinion finds fortification in Exhibit C3, which is the payment vouchers issued by the fourth defendant to each of the claimants. More so, it was never contended by the claimants that their payments was usually received from the fourth defendant. However, demands could be made by the local government councils to the third defendant, demanding for funds or payment of councillors. Hence, DW1 stated that this is done in a case where there is an issue. It is not out of place to reason that the non-payment of these claimants' salaries and allowances since 2002, after their tenure as councillors of the fourth defendant had expired, has indeed become an issue, which situation necessitated the writing of Exhibit C4, which is a supplementary list of unpaid salaries / allowances of political office holders in Umuahia North local government from 1999 to 2002 by the fourth defendant to the third defendant. It must be borne in mind that the Ministry of Local Government and Chieftaincy Affairs is not part of the claimants, but as the third defendant, and there are no facts or evidence that suggests the inference that the first defendant, that's the Abia State government, refused or failed to disburse funds for payments of councillors, including these claimants, as it is constitutionally obliged to do so. And based on this finding, and I am of the resolved opinion that the debt of 29,741,505 naira was 29,741,505 naira 30 kobo is owed these claimants by the third and fourth defendants jointly and severally, and should be satisfied by them. The Defendants Council had argued in issue 1 of his final submissions and arguments that these claimants are not in the category of office holders described in paragraph 32D of part 1 of the third schedule of the CFRM 1999 as amended, and section 6D of the Revenue Mobilization, Allocation and Fiscal Commission Act. The Defendants Council urged this court to dismiss this suit on the basis that these claimants are not entitled to be paid out of the Consolidated Revenue Mobilization Funds. Council placed heavy reliance on the case of Nwo Kedi versus Anambra State government and another, Supra. In effect, Learned Counsel for the defendants is likening the facts of the instant case to that of Nwo Kedi versus Anambra State government and another, and thus inviting this court to follow the decision of the Apex Court in deciding the case at hand on the force of judicial precedents. Firstly, it is important to understand the guiding principles to the application of the celebrated doctrine of stare decisis, or judicial precedents, in our judicial milieu. Elucidating on the nature of the principle in the case of Onyemezu versus Ojiako, citation supplied, the appellate courts held in the following words, and I quote, "The Nigerian court operating the common law religiously follows the doctrine of precedents in the enforcement of the judicial process. As a matter of law and tradition, they adore the doctrine. Under the doctrine, decisions of the superior courts are binding on the inferior courts. Put in another language, decision of a higher court is binding on a lower court, etc. However, a lower court is not bound to follow the stare decisis of the case where the facts of the case decided by the superior court is distinguishable from the case under consideration at the lower court, in which situation judicial precedent shall not apply." You may see Farahime versus MBA, citation supplied. Nwokedi's case was decided by the Apex Court upon the fact that the Anambra State House of Assembly enacted the Public Officers Salaries Law, number 7 of 2001. The said law, which took effect from the 29th of May 1999, provided for salaries of political office holders in the state, including local government councillors. It is notable that the said law number 7, 2001 was enacted pursuant to section 1241 of the CFI 1999, which empowers the House of Assembly of a state to prescribe payments to holders of offices mentioned in the said section 1241 of the Constitution but such payments shall not exceed the amount to be determined by the Revenue Mobilization, Allocation, and Fiscal Commission. The appellant had lost at both the trial court and at the Court of Appeal, each of which found that the appellant did not belong to the category of office holders envisaged and clearly mentioned in Section 124 of the Constitution and Sections 6(1)(d) of the Ramfact Act. Of course, dissatisfied by decisions of these two courts, the appellant appealed to the Apex Court. The Apex Court affirmed the decision of the Court of Appeal and dismissed the appeal. But worthy of clear emphasis is the generality of the case. I'll take that again. But worthy of clear emphasis is the generality of the case at the Supreme Court, which was summarized when their lordships held thus, and I quote, "Learned counsel for the appellant hearing has argued that a councillor is a political office holder. That may be so. The issue now is whether he comes within the purview of those officers whose salaries shall be determined and charged upon the consolidated revenue funds of the state by the Revenue Mobilization, Allocation, and Fiscal Commission, so as to warrant judgment being entered in its favor." End of quote. There is no gainsaying that the claimants in this suit, although they claimed against the, there is no gainsaying that the claimants in this suit, although they claimed against the defendants, I beg your pardon, the defendants jointly and severally have not narrowed their claims to any source from which the sum claimed is to be satisfied. These claimants had claimed as per the originating complaint as follows, and I quote, "The sum of 43,800,000 naira being the debt owed the claimants by the defendants arising from the statutory allowances and salary arrears as approved, computed, and or acknowledged by the defendants. The question of the consolidated revenue of the state never arose in the instant case. More worthy of emphasis is the profound fact that the suit of these claimants herein has not featured any law made by the House of Assembly of Abia State purporting to include local government councillors, including the claimant, among office holders whose salaries and allowances are chargeable or payable from the consolidated revenue of the states. I am therefore of the firm opinion that the facts and circumstances in Nwokedi vs. Anambra state government and another, Supra, are not in pari materia or on all fours with the facts of the instant case. Hence, the said case of Nwokedi vs. Anambra state government does not have the force of judicial preeminence on the instant suit, which must be followed, and I so hold. Thus said, I rest on the belief that the claimants have sufficiently proven their entitlements to the sum of 29,741,505 naira 30 kobo, being their overall unpaid salaries and statutory allowances. The third and fourth defendants are accordingly mandated to pay the said judgment sums to these defendants within 30 days of this judgment, after which the sums or what is left of it shall attract interest at the rate of 10% per annum until the entire sum judgment debt is entirely or completely paid. The claimant's case therefore succeeds with a cost of 500,000 naira awarded to them. Judgment is entered accordingly. That is all. Are you still there? Mr. Ogwo, you may unmute your microphone.
I'm still here. We thank you. It was a journey true evidence, the notice to produce the specific true pleadings, through constitutional law, through various aspects of law. It was quite a journey. I'm appreciative, not saying we, I am appreciative of the industry I've taken. Even distinguishing Nwokedi, you got the point at this of the consolidated revenue fund. We're thankful. We're very thankful, sir.
Thank you. You can give it
and even the recalculation, the financial recalculations.
I know somehow the government has to be involved in the payment, one way or the other. After all, it's a joint consolidated whatever technology you choose to use in the state administration. But we all know that the funds of the local governments are actually controlled by the state governments.
Yes.
So let's see how things can be done. We hope that things will get better. But
yes, sir.
You still have the opportunity of testing it upstairs, and I look forward to hearing from my elder brothers upstairs.
Yes,
so,
sir.
well, okay. You'll get a copy of the judgment immediately after proceeding today.
Yes, through the email, sir.
Yes, email. You can talk to the registrar because it has to be certified, but you can read it online within 5 minutes.
Yes, I know of the app. Yes, I know of the app, sir.
You'll get a certified copy of it immediately after.
Yes, sir. Thank you, sir.
I wish you all the best.
Thank you too, sir. Bye, sir.
Mr. Ebeziako is still there? Okay.
Very well, sir. But it's always a pleasure.
Yes.
Your Lordship company.
Thank you.
Even though this is a virtual proceeding,
yes,
I learned from the older brigade.
That's right.
And the court is never left bare.
That's true. So, I agree with you.
Enjoying the privilege of these proceedings.
I really enjoyed it.
I resolved to still abide by that indoctrination. I've enjoyed every bit of the proceedings.
Thank you. Thank you so much. I've enjoyed your presence too. And I look forward to more of it.
Very well.
All right. So, absence of any applications, court clerk?
Hello, that is all for today.
All right. I can see the registrar there. Registrar, good morning. How are you?
My Lord.
How is Owerri? How is Owerri today?
It's fine.
Okay, my best.
My Lord, I'm recovering well. I'm recovering.
Oh, you're recovering. Oh, well. I'm sorry, I didn't even ask. How is your health now? All right. Anyway, my best wishes to His Lordship Nelson. Send my regards to him and best wishes.
You will hear, my Lord.
All right. So you get the copies of the certified and signed copies.
That's copies, sir. Thank you, sir.
Thank you. All the best.
You too, sir.
All right.
Cut.